Welcome to Ignorantia Legas. It's the 30th of October 2020 and it is now our 29th episode. Taas ang gitag na cover magkaigsa na 29 episodes na ba? Sa law school pa ni, wala mag-midterm ta. Anyway, sa atong discussion for today will be about remedial law. So remember, every day mag-change the topic. So, based on the bar syllabus. Ang remedial law na ito kung magkaigsunan, by the way, if you missed some of our programs, you go to YouTube and subscribe and you like our page, you like our broadcast, post a comment, and also, by the way, aside from that, what do you call this? Aside from that, you can create a playlist and of your own choice, and you can look at all the episodes of Ignorantia Legas. So, na kay idea. You can play it while you're traveling. Kay lingaw ba? Okay. Ito na kay lingaw sa din laglo. Okay. Ngari kita sa naman na-discuss magkaigsunan, narita sa jurisdiction of the courts. Jurisdiction of the courts. The nature of Philippine courts. Meaning of a court. Philippine court. Now, the meaning of what is a court. No? A Philippine court forms part of the judicial department of the government of the Republic of the Philippines. Mura na siya o kanang it's the third branch of the government according to the Constitution. So it's paragraph 1, section 1, article 8 of the Constitution. A court is an organ of government belonging to the judicial department, the function of which is the application of the laws to controversies brought before it, as well as the public administration of justice, as well as the public administration of justice. Now, it is also the place where justice is administered. The Supreme Court and other courts. The judicial power shall be vested in one. Remember, judicial power shall be vested in one Supreme Court. That means there could only be one Supreme Court. Judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Paragraph 1, section 1, article 8, 1907 Constitution. Except sa butana. The Supreme Court is the one and only court that is created and vested with judicial power by 1987 Constitution. All other courts, Court of Appeals, Sandigan Bayan, etc., all other courts, which are therefore lower in the legal and administrative hierarchy, are created and vested with judicial power only by virtue of law. Manigitawag lang statutory courts. Courts created by mere statutes, laws. But the only court created by the Constitution is one Supreme Court. Dili duha ka Supreme Court, only one Supreme Court. Court as distinguished from a judge. A court is a juridical person within the purview of Article 44(2) of the Civil Code, which refers to other corporations, institutions, and entities for public interest or purpose created by law. Their personality begins as soon as they have been constituted according to law. So it's a juridical person, it's not a real person. Now, court versus a judge. A judge, on the other hand, is a physical or natural person. Now, the court is not a juridical person within the purview of Article 44(1) of the Civil Code, which refers to the state and its political subdivisions. Local governments refers to the political subdivisions established by or in accordance with the Constitution. Now, again, another distinction between a court and a judge. A court is a tribunal officially assembled under authority of law, while on the other hand, a judge is an officer of such tribunal. A court is an entity possessing a personality separate and distinct from the men who compose or sit on it. People versus Garcia, 1947. People versus Carlos, 1947. In the Carlos case, the Supreme Court ruled that the disqualification under the People's Court Act of some or a majority of the members of the Supreme Court and their substitution by justices of the Court of Appeals or judges of the Courts of First Instance do not make the Supreme Court, as thus constituted, a new court in the eyes of the law. This objection is no more valid than that of a party in an ordinary action who protests that this case is heard by a Supreme Court which, by reason of disability of a majority of its regular members, is made up mostly of judges from the outside. Jurisdiction does not attach to the judge but to the court. The continuity of a court and the efficacy of its proceedings are not affected by the death, the resignation, or cessation from the service of the judge presiding over such court. ABC Davao versus Court of Appeals, 1998. The reason is that the separate personality of the court from the judge is distinct, as described earlier. Now, the meaning of jurisdiction in various contexts. 1. Subject matter jurisdiction of a court. Jurisdiction over the subject matter is the power of a particular court to hear the type of case that is then before it. It is the power to hear and determine cases of the general class to which the proceedings in question belong. Reyes versus Diaz in 1941. Subject matter jurisdiction simply simply refers to the judicial power that has been vested in a specific type of court by the legal system in terms of what kinds of action it can decide. For example, regional trial courts as compared to Sharia courts, and what powers it can exercise in relation thereto. Example, issuance of provisional remedies. Specifically, with respect to the Supreme Court, it is the plenary judicial power vested in it by the Constitution, Section 5, Article 8 of the Constitution, of which it cannot be deprived by Congress pursuant to Article 2, Article 8. It includes the power of judicial review, which is the power of the courts to test the validity of executive and legislative acts for their conformity with the Constitution. Garcia versus Executive Secretary in 2009. Jurisdiction. What is jurisdiction? Jurisdiction is the power and authority of the court to hear, try, and decide a case. And B, it also has been referred to as the power or capacity given by the law to a court or tribunal to entertain, hear, and determine certain controversies. With respect to any other court, it is the judicial power vested in that particular kind of court by the pertinent law. For example, the jurisdiction of the Sharia Circuit Court is the judicial power that is vested in it by PD 103, Article 155. Now, three consequences automatically and inevitably flow from the judicial power conferred by law on a particular court. A. Subject matter jurisdiction exists only when and because it is prescribed by law. B. By the very essence of judicial power, subject matter jurisdiction can be vested by law upon a court. And C. Therefore, a body that purports to be a court is not a court if there is no law that has vested it with judicial power. For example, the Maing Tribal Court is not a court because there is no law that has vested it with judicial power. Padua versus Cordillera, 1991. The Civil Service Commission may have invested with the power to settle actual controversies under Executive Order 292, but it is not a court because it is not part of the judicial department of the government. Civil Service is an independent constitutional body. So those are the concepts in the jurisdiction over the subject matter. Now, jurisdiction over the person. Jurisdiction over the person. So, lahat itong jurisdiction over the subject matter, lahat po ng jurisdiction over the person. Jurisdiction over the person. It refers to what's the difference between jurisdiction over the subject matter and jurisdiction over the person? Jurisdiction over the person as compared to jurisdiction against the subject matter. So, for subject matter jurisdiction, it refers to the judicial power of a specific type of court over certain kinds of action as provided for and defined by law. There must be a law that defines it. When a subject matter jurisdiction. Now, jurisdiction over the person. It refers to jurisdiction over the person of a party in an action that has been filed with a specific court that has subject matter jurisdiction over such action by that specific court through modes acquired in procedural rules. Now, for example, you file a case. So it depends on the subject matter. Subject matter is about family, domestic issues, regional trial court, the family court. Now, if the subject matter is about homicide, then it would be the regional trial court. If subject matter is ejectment, then it would be with the MTC, municipal trial court. So it's very important to know. It's very important to know the subject matter. Now, even if you have jurisdiction for subject matter, the question is, do you have jurisdiction over the persons, over the parties? And that's the issue we're discussing right now. So first, you must have jurisdiction for subject matter, and then how does the court acquire jurisdiction over the parties involved? Okay, let's continue differentiating subject matter jurisdiction because jurisdiction over the person. Jurisdiction over the subject matter. None of the parties to the litigation can enlarge or diminish or dictate when it shall attach on or when it shall be removed ang jurisdiction over the subject matter. That is a matter of legislative enactment which none but the legislature will change. Manila Railroad versus Attorney General. Manila Railroad, ito pa, Meralco. Manila Railroad versus Attorney General, 1911. 1911. Important. Now, jurisdiction over the person. It may be conferred by consent, expressly or impliedly given to it. Or it may, by an objection, be prevented from attaching or removed after it has attached. So, subject matter, jurisdiction for subject matter, the parties cannot do that. Cannot enlarge or diminish it. The law defines it. But, jurisdiction for the parties, it may be conferred by consent, expressly or impliedly. May be objected to. Now, kinds of jurisdiction over the person. It could be jurisdiction over the person of the plaintiff. That's A. It could be B. Jurisdiction over the person of the defendant. And C. It could be jurisdiction over persons who are non-parties. Sa dili part sa kuyawan. Wa kay labot niya, malabot ka. Non-parties good. Now, let's discuss a little bit about jurisdiction of the person who are non-parties. It is a principle of equity that jurisdiction over a person not formally or originally a party to a litigation may nevertheless be acquired under the proper conditions through the voluntary appearance of that person before the courts. Ay, voluntary appearance mo ni Kuya. Thus, judgments may be directed against one who, although not a formal party in the case, has assumed or participated in the defense. Rodriguez versus Alikpala in 1974. So, let's go back to the plaintiff. How is jurisdiction by the courts acquired over the person of the plaintiff? Over the person of the plaintiff. Diba? Now, courts acquire jurisdiction over the person of a party plaintiff upon filing of the complaint. Regner versus Lugarta in 2007. See? The moment, if you're the plaintiff, the moment you file the complaint, the court already has jurisdiction over you. The plaintiff, having brought the action of necessity, submitted itself to the jurisdiction of the court. Manila Railroad versus Attorney General, 1911 case. So that's how the court acquires jurisdiction over the person of the plaintiff. So next, how does the court acquire jurisdiction over the person of the defendant? Over the person of the defendant. Jurisdiction over the person of the defendant is acquired generally by two manners, two modes. One, by his voluntary appearance in courts and his submission to its authority. Kadungog di siyang gi-file siya kaso. Tunga siya dito. Okay, kaso diri, sir. So that's voluntary appearance. Tunga ko kay gusto kong tubagan. Or, two, by service of summons. Iservan kasi mo summons, hindi. Makuhaan ka, maka-acquire niya kag jurisdiction. That's according to Rule 14, Section 20 of the Rules of Court. Now, jurisdiction over the person of the defendant is necessary for the court to validly try and decide a case only in an action in personam. If the action is in personam, then the jurisdiction over the person of the defendant is necessary. Otherwise, it will be an invalid trial. But jurisdiction over the defendant is not a prerequisite in an action in rem or in an action quasi in rem. So, sabot na ron ator pa na distinguish na sa in rem o sa quasi in rem. So it is not a prerequisite. Jurisdiction over the person of the defendant is not a prerequisite in an action in rem or quasi in rem, provided that the court acquires jurisdiction over the case. An objection to jurisdiction over the person of the defendant may be raised as a ground in a motion to dismiss. Rule 16, Section 1A. Kung sa mga motion to dismiss dito, sinawa pa mangganit na wala na siya. Again, the laws are interlocking. You cannot say part 1 rako sa law niya, di kung tanaw part 20. So, na siya. Interlocking. Diba, wala na ito. Maabot na ng panahon. Basta, you're just aware that an objection to the jurisdiction over the person of the defendant may be raised as a ground in a motion to dismiss or as an affirmative defense in an answer. Rule 16, Section 6, or support. So, lahi ng motion to dismiss, lahi po ng answer, lahi po ng reply. Under rules of courts, lahi ng answer na lahi ng reply. However, if not raised in such motion to dismiss or answer, a pleading called answer, it is deemed waived. It is not one of those defenses not deemed waived under Section 1, Rule 9. Boston Equity versus Court of Appeals. So, file kag motion to dismiss, file kag answer, nya wala ka mo question sa jurisdiction of the court over you, then it is not, your objection is deemed waived. Your objection is deemed waived. Alright, so only jurisdiction over the person. So first, nag-discuss ta earlier of jurisdiction over the subject matter, and then jurisdiction over the person. Now, jurisdiction over the issues. Uy, kaya na itong subject matter mo na issue. Napadilang issue. Number 3, jurisdiction over the issues. An issue is a disputed point or question to which parties to an action have narrowed down their several allegations and upon which they are desirous of obtaining a decision. The Supreme Court had occasion to note that in some instances, it has been held that the court must also have jurisdiction over the issues. That is, the issue being tried and decided by the court be within the issues raised in the pleading. Wa day mag-question og issue of ownership niya. Ni abot mo sa kuan, abot mo sa RTC. Niya ejectment na ang case, hindi na pwede. Generally, jurisdiction over the issue is conferred and determined by A. The pleadings of the parties which present the issues to be tried and determine whether or not the issues are of fact or law. B. Stipulation of the parties as when in the pretrial the parties enter into stipulation of facts or enter into agreements simplifying the issues of the case. C. Waiver or failure to object to evidence on a matter not raised in the pleadings. Here, the parties try with their express or implied consent or issues not raised by the pleadings. Kuya Osan? Okay. The rule is that a party entitled only to such relief consistent with and limited to that sought by the pleadings or incidental thereto. A trial court would be acting beyond its jurisdiction if it grants relief to a party beyond the scope of the pleadings. So, jurisdiction over the issues. Parehara ko na nagod nga. Mo claim ka og imong claim nimo 100,000. Di empty sira na. Kung ang gi-claim nimo payments, utang, payment 500,000 ngadto na sa RTC. So, asa may money issues, jurisdiction of the issues. So, the MTC no longer have, although the subject matter of non-payment, okay, non-payment of a loan, the subject matter is covered by the MTC, but the issue, if the issue is non-payment of 500,000 pesos, ang gi-claim is also 500,000 pesos, then mato na sa RTC. The subject matter, yes. Non-payment, yes. Collection for some money, yes. But the issue, no. So, money depends sa subject matter of issue. The subject matter of collection for a sum of money, non-payment of loan, for example, is clearly a subject matter within the jurisdiction of the MTC, Municipal Trial Court. But if the issue, the subject matter is collection for a sum of money, if the subject matter is 500,000 and it's over the 400,000 limit of the MTC, then MTC no longer has jurisdiction over the issue. So, Let's distinguish between subject matter and issue. Now, lain. So, kwata, jurisdiction over the subject matter, jurisdiction over the person, jurisdiction over the issue. Karon, jurisdiction over the rest. Mga na niron. Libog kayo ni siya. Because the rest could be subject matter, could be an issue. Libog ta. Sige lang, maglibog mo. Libog mo yun ang nagkumagbar. Jurisdiction over the rest. Res in civil law, ano ba siya, Latin na term, is a thing or object. It is everything that may form an object of rights as opposed to a persona which is the subject of rights. It includes object, subject matter, or status. Yan res. Jurisdiction over the rest to the court's jurisdiction over refers to the court's jurisdiction over the thing or the property which is the subject of the action. Jurisdiction over the rest may be acquired A. By seizure of the thing under a legal process whereby it is brought into actual custody of the law. Custodia leges. Custodia leges. Or B. From the institution of legal proceedings wherein, under special provisions of law, the power of the court over the property is recognized and made effective, is the potential jurisdiction over the rest. El Banco Español Filipino versus Palanca in 1918. In order that the court may exercise power over the rest, it is not necessary that the court should take actual custody of the property. Kung property di ay yuta. Mga to din korte dito. Potential custody thereof being sufficient. There's potential custody when, from the nature of the action brought, the power of the court over the property is impliedly recognized by law. Perkins versus Dizon, a 1939 case. So, kana mga case nga, 1939, mga tawag na ito landmark case. This is the first case involving this issue. In a quasi-in rem action, jurisdiction over the person of the non-resident defendant, sabot ang non-resident, not a resident of the Philippines. Example to was America. In a quasi-in rem action, the jurisdiction over the person of the non-resident defendant is not necessary, and service of summons is required only for the purpose of complying with the requirement of due process. An action quasi-in rem is an action between parties where the direct object is to reach and dispose of property owned by them or some interest therein. De Migli versus Ferrandos in 1975. The Court of Appeals, not the Court of Tax Appeals, has jurisdiction over the case alleging non-compliance with the pertinent provisions of the local government code on tax delinquency sale. Anday tax delinquency sale, Pero dili Court of Tax Appeals. Is the Court of Appeals that has jurisdiction. Kana, probable bar question na siya. A plain reading of Magpile's petition before the RTC would show that he did not assail the legality or validity and reasonableness or correctness of the real property tax assessment and collection. What he is questioning is the alleged denial of due process in the levying of his property. So, na. Jurisdiction over the subject matter, jurisdiction over the person, jurisdiction over the issue, jurisdiction over the rest, especially in an action quasi in rem. Kunya, hapit na time, di na ko magsugod og laing pang topic kay magtaas-taas. Okay. Now, jurisdiction versus the exercise of jurisdiction. Lain na siya. Naka-jurisdiction, naka-exercise of jurisdiction. Remember, in the exercise of jurisdiction, you could be wrong. You might have jurisdiction, but when you exercise your jurisdiction, we actually used your jurisdiction, we executed it. You could be wrong in the exercise of jurisdiction. That's why you must distinguish between jurisdiction and the exercise of such jurisdiction, because they have two different remedies. Jurisdiction refers to the power or authority of the court. Power or authority of the court to hear and decide a particular case or controversy. While the exercise of this power or authority is called the exercise of jurisdiction. Jurisdiction is not the same as the exercise of jurisdiction, as distinguished from the exercise of jurisdiction. Jurisdiction itself is the authority to decide a particular cause, a particular case, and not the decision rendered therein. Where there is jurisdiction over the person and the subject matter, the decision on all other questions arising in the case is but an exercise of jurisdiction. And the errors which the court may commit in the exercise of jurisdiction are merely errors of judgment, which are the subject proper of an appeal. Tolentino versus Levistin, 2004. By the way, jurisdiction is the power to decide. But when you decide, when you exercise your jurisdiction, when you make a decision and you committed an error there's an error in judgment, which is an error in the exercise of such jurisdiction. Yes, you had the power, but you did not exercise it properly. Now, what is the difference between an error of jurisdiction versus an error of judgment? Simple. You can, in summary, errors jurisdiction, you really didn't have the power, sub-jurisdiction over. You didn't have the power over either the person, the subject matter, the rest, or the issues. But if you don't have that, then the whole thing is void. the whole process is void. But if it's just error of jurisdiction, error of judgment, that means to say the judge as a person made an error in the exercise of just jurisdiction. So it's an error of judgment. Okay, but let's look at the detailed differences. Error of jurisdiction. One is where the act complained of was 1. Without jurisdiction or in excess of jurisdiction, or 2. With grave abuse of discretion amounting to lack of jurisdiction. So that is error of jurisdiction. With error of judgment, one which the court may commit in the exercise of its jurisdiction. It includes errors of procedure or mistakes in the court's findings. So error or mistakes in the court's findings, so error of judgment. Another difference in the exercise, error of jurisdiction and error of judgment. Error of jurisdiction is correctable only by the extraordinary writ of certiorari or certiorari. Although Section 8, Rule 40 allows an RTC with original jurisdiction over a case brought on from a lower court without jurisdiction over subject matter to decide the case on the merits. Okay? Ang lower court, isaka mo na sa RTC. Pwede ang RTC na may exercise na. So, error of jurisdiction is correctable only by an extraordinary of certiorari. Error of judgment, correctable by appeal. Now, error of jurisdiction, decision is a total nullity. If there's a decision and you originally had an error of jurisdiction, the decision is a total nullity. It's void. It's void and may be struck down at any time except on appeal. Except when the party raising the issue is barred by stupil. Stupil ka. Or the concept of stupil, at po nang i-discuss. Mag-interlink ang mga principles. Di pa ni masabtan dahil maglisod ang first year law student masabtan. But anyway, remedial law is discussed in the 3rd year. So ato first year pa na to, first time na remedial law. Advance ani? Okay. Next year mo ba ta? Now, error of jurisdiction means erroneous judgment, and it is not the same as a void judgment. It's just an erroneous judgment. It's not a void judgment. It's just an erroneous judgment. A void judgment, an erroneous judgment is not necessarily a void judgment. Alright, so anyway, salamat sa pag-uban ka na kung maka-exonan kini si Gentlemen sa episode 29 sa Ignorantia Leges, October 30, 2020. See you tomorrow.